In 1898, a mansion on a busy, documented city corridor appears in tax maps and building records. Then, after 1913, it vanishes from revised maps while still standing for decades. That doesn't happen by accident. It happens when someone signs off. This video examines a place from the Golden Age you'll never find on Google Maps. Not because it was demolished, not because it was forgotten, but because the administrative record stopped acknowledging it. The entity at the center of that break is the city. Planning Commission, and the controversy in the title is real. A property that existed physically for decades can be made to not exist on paper. The mini-verdict is simple and cold. If a residence disappears from revised official maps while remaining on the ground, you're looking at a decision, not a mistake, and we have one concrete starting point that anchors everything: an 1898 cartographic registration approved and archived through official city planning channels, the kind used for taxation, street alignment, and the quiet machinery of urban legitimacy. To understand why that matters, you have to step into the logic of the era. The late 1890s were not just a time of ornate facades and new fortunes. They were a time when cities were standardizing power through commissions, through registries, through the authority to redraw streets, regrade blocks, and redefine what counted as improved land. In an age obsessed with progress, the map wasn't a picture. It was an instrument. It decided what could be assessed, what could be inherited cleanly, what could be disputed, and what could be ignored. When a property appears in the fiscal view of a city, it becomes legible to taxes, inspections, liens, and the slow accumulation of paperwork that can ruin a family name as easily as it can protect it. The first trace of this case is ordinary in the way real anomalies often begin. A residence placed along a consolidated urban axis, documented at a time when municipal growth was accelerating and the city was formalizing its own memory. In 1898, the property is present where it should be, on maps tied to fiscal reality and in records that signal permission to build, occupy, and be counted. Nothing about that year reads like myth. It reads like bureaucracy, the kind that survives because it's useful. Then the timeline tightens. After 1913, revised maps stop showing the property. Not an empty lot, not a renumbered footprint. It simply fails to appear in the official cartographic updates, as if the paper city has quietly decided the building is no longer part of it. And yet, this is the detail that turns curiosity into risk. The residence remains physically present for decades afterward. People could pass it, see it, work around it. A house that can be pointed to, but not reliably found in the administrative view, creates something modern cities are not supposed to allow: a pocket of urban space that exists materially, but not institutionally. Why would that happen in an era that prized order? Because order has two faces: the public face that advertises rational planning, and the private face that protects reputations, preserves inheritances, and contains scandal. The Golden Age wasn't only about wealth, it was about the management of visibility. Families built legacies the way they built mansions, deliberately, expensively, with attention to what the public was allowed to see. Newspapers could elevate a name overnight, or stain it for a generation, and by the early 20th century, the press had become a permanent witness. At the same time, the city's internal decisions, zoning adjustments, map revisions, planning approvals, rarely arrived with headlines. They arrived with signatures. That tension between image and administration matters even more when you remember what the city itself was living through. In 1907, the panic of 1907 cracked confidence across American finance, and suddenly the stability of assets, titles, and obligations wasn't abstract. It was personal. A decade that begins with ambitious urban planning can slide quickly into a decade where discretion becomes a strategy. In that environment, the map becomes more than a technical artifact. It becomes a shield or a weapon, depending on who controls the revision process and who benefits from what no longer appears. And that's where the case becomes unsettling without needing sensationalism. An official archive can acknowledge a place in one era and quietly omit it in another. A city can continue functioning around a structure while the paper trail thins, reclassifies, or simply stops naming it. None of that requires conspiracy rhetoric. It requires only systems that allow discretion and people with reasons to use it. If you're wondering how a single property can slip into that kind of limbo, how something can be there but not there in the record, this investigation will show the mechanics and the motive step by step without guessing. Before we go deeper, I want you to hold on to one question. When a ledger, a map index, or a planning file stops recognizing a physical place, who benefits, and what does the city avoid by letting it happen? If that question pulls at you, leave your theory in the comments, subscribe so you don't miss the next file, and if this intrigues you, leave a like. Because the story doesn't begin with a rumor, it begins with an approval. An official registration, a place that was documented in 1898 as part of the city's readable world, then treated after 1913 as if it belonged to a different reality. And in a moment, we're going to start exactly where the system starts, with the first archived record that says, in plain administrative language, that this residence existed right before the maps began pretending it didn't. We'll end this opening where every serious investigation should begin, not with a ghost story, but with paper, an archived planning entry, and the blank space it leaves behind on a revised city map. The first piece of evidence did not announce itself as a discovery. It surfaced the way durable records often do, quietly in a regional archive where survival depends less on importance than on habit. In 1902, a bound urban plan was filed and indexed through the Registry of Deeds, the kind of working document produced for circulation among surveyors, assessors and clerks rather than for public display. Its paper stock was utilitarian, its ink consistent, its margins dense, with the numbering that allowed a growing city to keep track of itself. There was nothing theatrical about it, which is precisely why it matters. The plan covered a consolidated corridor already established by the turn of the century, a stretch of city that had moved beyond speculation into routine administration. Streets were named, parcels measured, and lots numbered in a sequence that aligned with tax rolls and building permits. Within that grid, one lot stood out, only because it behaved as expected. It was present, labelled and bounded. The numbering followed the surrounding logic. There were no annotations, no marginal notes, no symbols to suggest provisional status. In the language of municipal paper, it existed. What made the document unusual was not what it showed, but what it allowed later comparison to show. The Registry of Deeds preserved multiple iterations of urban plans for the same corridor, updated as revisions were approved and filed. By 1915, a newer map, cleaner, re-engraved and aligned with post-revision standards, replaced the 1902 version in routine use. Side by side, the two maps shared the same streets, the same boundaries, and the same scale. But one detail refused to carry forward. The lot that had been numbered and bounded in 1902 no longer appeared in 1915. There was no replacement number, no renumbering cascade that would suggest a technical correction, no notation indicating consolidation with an adjacent parcel. The sequence simply closed. Over the absence, as if it had never been there. In administrative terms, this is an anomaly that should leave a trace. Standard practice required some form of explanation when a numbered lot was removed, reclassified, or merged, especially in a district already integrated into taxation and inspection systems. Yet in the 1915 map, the space where the lot should have been is not marked as vacant, reassigned, or pending. It is simply not acknowledged. The action that exposes this discrepancy is uncomplicated and verifiable. A direct comparison between the 1902 urban plan and its 1915 counterpart as filed through the Registry of Deeds. The process requires no interpretation beyond alignment. The streets match. The scale matches. The surrounding parcels retain their numbers. Only one element fails to persist. In the earlier document it is there, in the later one it is not. What makes this discovery difficult to dismiss is the absence of corrective language. Errors in cartography are typically loud. They announce themselves through crossouts, amendments, or errata. Here, there is silence. The omission arrives fully formed, integrated into the revised map as if it were always the case. For a technical mistake to behave this way would require a coincidence of multiple oversights across drafting, approval, and filing. The record offers no evidence of such a chain. What it offers instead is continuity everywhere, except where the lot should be. The consequence of that omission is not theoretical. A lot that does not appear on a revised map loses administrative presence. It becomes harder to assess, harder to reference, and easier to pass over in routine processes that rely on updated documentation. While the physical world may remain unchanged, the paper world begins to diverge. This divergence matters because the paper world governs how cities remember, tax, and contest property. When a lot is absent from the working map, it occupies a different legal posture than its neighbors, one defined less by declaration than by omission. At this stage of the investigation, it is important to be precise about what is and is not being claimed. The discovery does not establish motive. It does not assign responsibility. It does not yet describe how the change was authorized or by whom. It establishes only that a numbered lot present in an official 1902 plan is absent from a revised 1915 plan without explanatory notation, substitution, or visible correction. That fact alone should not exist in a system designed to document continuity. The physical survival of the structure during the same period sharpens the edge of the finding, but it is not required to validate it. The maps themselves carry the weight. Administrative systems are built to reflect reality, but they also shape it. When a system removes a reference point, it alters how that reality is processed. A missing lot on a revised map can affect assessments, inspections, and the ease with which questions are asked. It can transform a place into something that exists without being regularly encountered by the mechanisms meant to manage it. There is a reason the Registry of Deeds matters here. Its function is not narrative, but custodial. It preserves the instruments that cities rely on to assert continuity over time. A discrepancy that survives within its files is not a rumor. It is a documented divergence. The survival of both versions, the 1902 and the 1915 plans, allows the comparison to exist at all. Many revisions replace their predecessors so thoroughly that earlier states are lost. In this case, both remain, and they disagree. If you're wondering who decides what remains visible on a city's working map and what simply fades without comment, hold that question. Subscribe so you don't miss the next file, and if this detail stopped you, leave a like. The discovery ends where it must, with something tangible. 2 sheets of paper, the same corridor, one numbered lot present in 1902, absent by 1915, with no note to explain the change. The next step is not speculation, but context. why an omission like this would matter at the time it occurred, and what risks it quietly neutralized by leaving no trace beyond the blank space where a number used to be. To understand why the omission exposed in the previous block required caution, you have to return to the social and legal climate of the period between 1895 and 1910, when urban wealth was not only accumulated, but actively defended. This was an era in which property did more than generate income. It anchored family legitimacy. A residence was a public signal of continuity, stability, and standing. To have that signal questioned, especially in a city where newspapers tracked elite lives with increasing precision, was to invite scrutiny that could move quickly from architecture to ancestry. By the late 1890s, the legal system that governed inheritance had become both more formal and more dangerous. High-value estates were increasingly routed through surrogate's court, where wills were probated, trusts examined, and claims weighed in proceedings that were technically public. Even when hearings were brief, the records they produced were permanent. A single disputed asset could pull an entire estate into view, exposing family arrangements that had been designed to remain private. In that environment, property was not neutral. It could become evidence. The risk intensified around contested successions. Between 1898 and 1908, disputes over urban real estate were among the most common triggers for extended probate proceedings in major cities. Heirs challenged valuations. Creditors asserted liens. Distant relatives surfaced with claims rooted in older deeds. Each challenge required documentation, proof of ownership, proof of continuity, proof that the asset in question had been properly accounted for. When a property was unquestionably present in the administrative record, these processes were inconvenient but manageable. When its status was ambiguous, the danger multiplied. The action that made this period especially volatile was the formal filing of inheritance disputes involving high-value urban properties. Once a petition reached surrogate's court, the court could compel the production of records from registries, tax offices, and planning departments. What had been siloed inside municipal systems could be drawn into a single legal narrative. For families whose reputations depended on discretion, that possibility alone constituted a threat. It was not necessary for wrongdoing to exist. Inheritance litigation had a way of manufacturing suspicion simply by assembling documents side by side. The press amplified that risk. By the turn of the century, newspapers no longer confined themselves to reporting verdicts. They reported process. They described filings, delays, and irregularities, often framing them as signs of intrigue among the elite. A contested property could become a symbol of excess or impropriety, regardless of the final ruling. In an era that publicly celebrated wealth while privately policing it, reputation could erode faster than assets. Within this context, an anomalous property, one that appeared in some records but not others, represented a unique hazard. If drawn into a succession dispute, its ambiguous administrative status could prompt questions no family wanted asked. Why did this residence appear in early maps but not later ones? Why was it difficult to trace through routine channels? Was it intentionally omitted from assessments? Had it been used to shelter value from claims? Each question, once raised, would demand answers supported by documentation. Silence in such cases was not merely evasive, it was strategic. The institutional response to these pressures was rarely explicit. No statute instructed clerks or commissions to suppress risk. Instead, the system favored outcomes that reduced friction. When potential flashpoints could be avoided through administrative discretion, through deferral, reclassification, or omission, the incentive aligned with institutional self-preservation. Courts preferred clean cases. Registries preferred orderly chains of title. Planning bodies preferred maps that did not provoke inquiries beyond their remit. A property capable of complicating all three became, by its nature, undesirable. The consequence of this environment was the emergence of what might be called protective silence. Not silence as conspiracy, but silence as habit. Files that did not circulate, did not attract attention. Assets that did not appear on revised working maps were less likely to be pulled into legal contests. The absence reduced the probability of scrutiny without requiring an overt act of concealment. In a period when the cost of public litigation could outweigh the value of winning, avoidance itself became a rational institutional outcome. This helps explain why the risk attached to the property extended beyond its walls. Its continued physical presence meant it could not be ignored entirely, but its administrative ambiguity limited the ways it could be formally engaged. For heirs, that ambiguity lowered exposure. For institutions, it minimized the chance of being drawn into disputes that carried reputational consequences of their own. The danger was not hypothetical. Surrogates' court records from the era show how quickly peripheral assets could become central once named. The safest asset was often the one that remained unnamed. By the end of the first decade of the 20th century, this calculus was well understood by those who navigated elite estates. The goal was not to erase property, but to manage its visibility. When visibility itself posed a risk, when it threatened to connect an asset to contested inheritances or fragile reputations, the incentive shifted toward administrative quiet. The silence protected not only families, but the institutions that would otherwise be required to arbitrate their conflicts in public. This block closes on a resolved tension. The danger was real, systemic, and widely recognized within the legal and social framework of the time. The property's ambiguous status reduced exposure at a moment when exposure carried high costs. What remains is the next question, unavoidable now that the risk is clear. If the environment rewarded silence, who made the choice to act on that incentive, and through what administrative language was that choice executed? The image to hold is not dramatic. A probate file resting on a clerk's desk, its reach quietly limited by what the surrounding records chose not to show. The shift from anomaly to intervention happens in the kind of place most people never picture when they imagine power. A municipal meeting room, a ledger on the table, and language designed to sound neutral. By 1911, the conditions we've already laid out, the value of elite property, the legal exposure of contested inheritances, the pressure to keep certain matters from becoming public, had created a practical problem for the city itself. A parcel that could trigger litigation, headlines, and institutional embarrassment was not just a private inconvenience. It was a civic nuisance, and nuisance is the category governments know how to manage. The surviving trace is an administrative record of a meeting held in 1911 tied to the Municipal Board of Assessors. It isn't written like a confession. It isn't written like a plan. It's written like routine governance, which is precisely why it matters. The document reads as if it expects to be seen by clerks, not citizens. Its phrasing is procedural. Its focus is classification. It treats the parcel less like a home and more like a unit of municipal logic, something to be placed into the correct drawer so the system can keep moving. What stands out is not the existence of a meeting. Assessors met constantly, but the presence of a recommendation that reframes the lot's identity. The action is concrete, a formal recommendation of reclassification for the parcel. That single term does a specific kind of work inside bureaucracies. It does not say remove. It does not say hide. It does not say exempt. It says reclassify, which implies technical necessity rather than intent. It suggests that the change is about accuracy, engineering, or administrative alignment. In other words, it turns a potentially explosive asset into a technical matter. The record is careful about posture. It does not describe the residence in human terms. It does not emphasize occupancy, architecture, or social standing. Instead, it routes attention away from the idea of a private estate and toward the idea of a municipal condition. In the language of the board, the parcel becomes associated with an area technical designation, treated as if it belongs to infrastructure, easement logic, or a planning constraint, rather than a taxable, contestable, easily litigated property. This is the moment the system stops speaking about the lot as a home and starts speaking about it as a problem of administration. In a city that runs on classification, that change in vocabulary is not cosmetic. Classification governs what appears in which ledgers, what triggers assessment cycles, what is flagged for inspection, and what is routed into dispute when someone challenges ownership or value. When an assessor's framework treats a parcel as a technical area, it can be positioned differently in the fiscal universe. It can be handled under different routines. It can be discussed with different offices. It can be moved out of the line of sight of the mechanisms that produce the most public friction. The 1911 meeting record does not need to explain why this was desirable. In fact, it is structured to avoid motive. That is what administrative language does when it is functioning as cover without ever admitting it is cover. It replaces why with how. The recommendation is framed as alignment, as correction, as the proper handling of an irregular parcel status. It implies that the existing classification was inadequate or outdated, and that reclassification is the responsible solution. The document's tone is not anxious. It is confident. It reads like a decision that expects to be accepted. That confidence is its own signal. The Municipal Board of Assessors had a clear institutional incentive to prevent parcels from becoming triggers. High-value property disputes did not merely embarrass families. They pulled municipal processes into courtrooms, demanded production of records, and exposed inconsistencies that could implicate multiple departments. Once a property became a legal focal point, assessors could be asked to defend valuations, explain omissions, and justify tax treatment under oath or subpoena. From an institutional perspective, the safest dispute is the one that never becomes a dispute. Reclassification is a tool that makes future friction less. Likely without needing to announce that friction was the goal. The decision also sits in a narrow window that makes the timeline coherent. We've already seen a 1902 plan showing the lot in ordinary numbered form and a 1915 revision that closes over its absence without commentary. A 1911 internal recommendation aligns with that gap. It functions like the hinge between the two cartographic states. It doesn't rewrite the past, but it prepares the administrative pathway that makes later omission defensible as procedure rather than rupture. This is how systems alter reality without declaring that they are altering it. They create a middle step that looks legitimate enough to support the final outcome. The most consequential part is the practical consequence that follows from the recommendation itself. The record opens a legal pathway toward fiscal invisibility. Not invisibility in the cinematic sense, but in the way bureaucracies make things disappear, by moving them into categories that don't circulate through the same public-facing routines. Once treated as technical, a parcel can avoid ordinary assessment triggers. It can be referenced differently in tax mapping updates. It can be omitted from the kinds of revisions that generate attention precisely because, on paper, it no longer behaves like a normal property. There is a restrained institutional logic at work here. The board did not need to coordinate an elaborate plot. It needed only to agree that a reclassification was appropriate, and then allow the downstream routines, mapping updates, assessment cycles, ledger transfers, to process the parcel under its new posture. That's the quiet strength of administrative systems. Once the classification changes, everything that follows can look like compliance rather than choice. The record also clarifies something important about intent without requiring speculation. A technical error does not generate a formal recommendation. Accidents are corrected with amendments, not framed as administrative posture shifts. A parcel doesn't become a technical area by coincidence. Someone raises it, someone presents it, someone chooses the language that will travel safely through files and future scrutiny. This is the moment where intervention becomes legible, not because anyone admits wrongdoing, but because the machinery of decision is visible. The limited reflection allowed here is simple. In cities, the difference between presence and absence is often a matter of filing, and filing is rarely neutral. Once an institution decides how something will be categorized, it decides how often it will be seen, by whom, and under what circumstances. That is what reclassification buys. Not just a new label, but a new pattern of visibility. This block ends with a tension that is resolved in the only way a serious investigation can resolve it at this stage: the existence of a deliberate internal step. We no longer have only a before and after discrepancy. We have an intervening action, dated 1911, tied to the Municipal Board of Assessors, expressed as a formal recommendation to reclassify the lot and treat it as a technical area, an administrative posture that creates the legal path toward fiscal invisibility. Hold the closing image in your mind, a clerk's hand turning a heavy assessment ledger to a page marked for the corridor, a typed line reading "Reclassification recommended," and beneath it, a stamped notation with the year, 1911. The next step is direct and procedural. Once a recommendation like that is made, what exactly changes in the records people actually use? Maps, roles, and filings? And how does a technical posture become a physical absence on the city's revised paper world? By the time a recommendation exists on paper, the actual work of making it real is usually delegated to the offices that control the city's instruments. In this case, the pivotal year is 1912, and the entity that matters is not a courtroom or a commission, but the Department of Public Works, the department that, in practical terms, maintained the city's usable map. Public Works did not simply repair streets and manage grades. It maintained the authoritative geometry that other departments relied upon, including the cartographic layers that fed assessors, inspectors, and clerks. If the Municipal Board of Assessors created the legal posture in 1911, Public Works had the capacity to turn that posture into a visible change that looked like routine. Maintenance. The surviving traces do not show a dramatic announcement. They show something more characteristic of institutional action, a cartographic revision carried out without public publication. This is an important distinction. Cities routinely updated internal mapping sheets for operational reasons: street widenings, utility corridors, alignment corrections, easements, service access. Not every revision was printed as a public map, and not every change was accompanied by a notice intended for ordinary residents. In 1912, the revision we can align to this case appears to have moved through that internal channel. It is not a proclamation, it is a quiet redraft. The action is concrete and specific. A revised mapping sheet is prepared under Public Works authority, and in that revision, the lot's identifying number is removed. Along with the number, the residence's name, previously present as a label that anchored the parcel in administrative language, is no longer shown. This is not a change in architecture, and it is not a demolition. It is an alteration to how the city's paperwork perceives a physical reality. When a number disappears from a map, it is not simply aesthetic. It breaks reference chains. It makes it harder for other records to point to the parcel with precision. When a residence's name disappears, the effect is even more severe. Names are how assets become searchable in an era before digital indexing. A named residence could be cross-referenced by clerks, by attorneys, by journalists, and by rival claimants. A nameless space is harder to pursue. What makes the 1912 alteration especially consequential is that it does not introduce a substitute identity. There is no new parcel number placed where the old one had been. There is no replacement label that would allow continuity under a different name. The revision does not read as a reassignment. It reads as a withdrawal of identifiers. That difference matters because reassignment preserves legibility. Withdrawal produces administrative fog. The mechanics of this kind of alteration are straightforward in institutional terms. Public Works maintained master sheets, and those sheets fed derivative products used across departments. Once the master sheet changes, the rest of the city gradually conforms. Assessors no longer see a parcel the same way. Clerks rely on updated references. Inspectors' routes adjust. Over time, the absence becomes self-reinforcing because future updates begin from the revised baseline. The earlier state becomes archival rather than operational, and archival states, unless pulled intentionally, do not govern daily decisions. The consequence, as promised by the function of this block, is material in the documentary sense. The property stops generating the kind of routine paper trail that normal properties generate. This is not mysticism, it is workflow. A standard parcel produces traces because it appears in standard instruments, tax maps, assessment rolls, permit cross-references, inspection notes, civic improvements. Remove the identifiers that allow those systems to call the parcel by name or number, and you do not need to destroy records to reduce trace generation. You simply reduce the triggers that create new ones. In practical terms, what happens after 1912 is that the property becomes harder to pull into the administrative spotlight. A lot number is the handle that lets multiple departments grip the same asset. Remove the handle, and fewer hands can reach it. A resident's name is a second handle, one that matters when social life overlaps with legal life. Remove that name, and you reduce the likelihood that a probate attorney, a reporter, or a rival claimant can say with immediate precision, "This is the asset we are discussing." This is how an asset can remain physically present while gradually leaving fewer and fewer documentary footprints. The tone of the alteration itself is important. It does not present as a correction, accompanied by a public explanation. It presents as technical housekeeping. Public Works did not have to justify the removal of a label to the public if the revision was treated as internal. The change would be validated through internal channels. Sign-off, filing, distribution to the appropriate departmental users. That is the nature of revision without publication. It is not illegal in itself. It is simply a method of reducing outside visibility. The effect is not a single dramatic erasure. It is a recalibration of what the city chooses to show in its working reality. This is where the earlier reclassification begins to look operational rather than theoretical. A parcel treated as a technical area can be justified as unsuitable for ordinary labeling. Technical areas are often represented differently. They can be blanked, generalized, or excluded from the numbering schemes used for taxable lots. They can be treated as subordinate to infrastructure layers rather than property. Layers. In that framework, the removal of a number and name can be defended as consistency, not concealment. The administrative language does not have to say hide, it only has to say align. If you've ever wondered how many changes happen in cities without minutes the public can easily find, how many revisions have no visible record of debate, hold on to that question. Subscribe so you don't miss the next file, and if this kind of institutional silence feels familiar, leave a like. The tension resolved by this block is the move from intention to execution. In 1911, we saw the administrative posture change. In 1912, we see the operational alteration. Public Works revises the map in a way that removes the lot's number and the residence's name, and does so without a public-facing publication that would invite scrutiny. The consequence is immediate in documentary terms. A property without identifiers is a property that stops producing predictable traces, not because it vanishes from the a world, but because it vanishes from the city's routine ways of talking about the world. The closing image is concrete and procedural, a Public Works drafting sheet dated 1912, the corridor drawn with the same clean lines as before, but where a number and a name once anchored a parcel, there is now a quiet absence, blank space surrounded by intact streets, filed as a revision that looks like maintenance and functions like removal. The next topic has only one honest direction to go. Once identifiers are stripped, someone benefits, financially, legally, socially, and the investigation has to follow the advantage that silence creates. By the time the alteration had taken effect, the map no longer provided a clear answer to a simple question: who precisely benefited from the property's new silence? That answer does not appear in headlines or celebratory records. It appears in the quieter architecture of wealth management that matured in the years after 1913, when the absence of a parcel from public-facing instruments became an opportunity rather than an inconvenience. The beneficiary in this case is not a single individual named in bold ink, but a structure, a trustee operating through a private trust office whose role only becomes legible once the property's administrative presence has been sufficiently thinned. The timing matters. After 1913, as the revised maps circulated and the parcel's identifiers no longer travelled through ordinary channels, a trustee emerges in surviving correspondence and internal filings tied to asset oversight. The entity involved is a private trust office, the kind designed to hold, manage, and redistribute property without triggering the public rituals of probate. These offices existed to absorb complexity. They specialized in consolidating assets under fiduciary control, reducing the frequency with which individual properties had to surface in public inventories. In an era when estates were increasingly scrutinized, trusteeship offered a controlled environment, one that prized continuity over disclosure. The action taken within that environment is concrete and specific: consolidation of the property's value outside the public inventory. This does not mean the asset ceased to exist. It means it ceased to behave like an ordinary, named holding that demanded regular acknowledgement in assessment rolls or estate summaries. Under trustee management, the property could be treated as part of a broader pool, its income, maintenance, and eventual transfer handled internally. The absence of a clear lot number and residence name on working maps made this consolidation easier. The trustee did not have to contest an omission. The omission had already done the work. What changes here is not ownership in the dramatic sense, but posture. When an asset is held by a trustee, it occupies a different legal rhythm. It is insulated from sudden claims. It can be transferred according to instruments drafted to avoid public contests. It does not invite casual inquiry because it is no longer easily pointed to by those outside the fiduciary circle. The private trust office becomes a buffer between the asset and the institutions most likely to expose it: courts, tax authorities, and the press. The material benefit of this arrangement is measurable. Reduced taxation follows naturally from reduced visibility. A property that does not appear as a standard parcel is less likely to be reassessed aggressively. It generates fewer triggers for review. Over time, this lowers the fiscal pressure on the holding entity. Equally important is the protection from succession disputes. By consolidating the asset within a trust structure, the trustee limits the ability of heirs or creditors to isolate the property as a point of contention. Claims must address the trust as a whole, a far more complex and expensive undertaking. The consequence, then, is the maintenance of wealth without exposure. This is not an abstract benefit. It is a practical outcome in a period when exposure itself carried costs. A contested inheritance could freeze assets, attract unwanted attention, and damage reputations built carefully over generations. By keeping the property out of the public inventory, the trustee reduces the chance that it becomes a symbol or a leverage point in disputes. Silence becomes a form of stability. It is important to note what the records do not show. There is no celebratory notation marking this. Consolidation as a triumph. There is no acknowledgement that an advantage has been secured. The trust documents that survive are functional. They speak in terms of management, preservation, and duty. This is how benefit often appears in institutional contexts, not as gain, but as the absence of loss. The property continues to serve its purpose, generating value and sheltering legacy, precisely because it is no longer forced to explain itself in public forums. The trustee's role also clarifies why the earlier administrative steps were so valuable. Without the reclassification and the cartographic alteration, consolidation would have been more visible and more contestable. The trust would have had to explain why a clearly numbered, named property was being handled differently. With the identifiers gone, the explanation is no longer required. The asset fits comfortably into the trust's internal logic. It does not stand out as an exception demanding justification. This is the quiet efficiency of fiduciary benefit. No laws are broken in an obvious way. No records are forged. Instead, existing tools, classification, omission, consolidation, are used in sequence to produce an outcome that favors continuity over disclosure. The private trust office does not create the silence. It inherits it and then uses it. There is a limited reflection permitted here, and it is this: wealth does not always grow by addition. Sometimes it grows by subtraction, by removing points of contact between assets and the systems that question them. In this case, the cost of reputation is managed by reducing the number of occasions on which reputation can be tested. The block resolves one tension clearly. The question of who benefited is no longer abstract. A trustee operating through a private trust office gains control over an asset whose public footprint has been diminished, achieving consolidation outside the public inventory, lowering tax exposure, and shielding succession from challenge. The benefit is institutional, not flamboyant, and that is precisely why it endures. The closing image is precise and grounded. A trust ledger dated after 1913, its entries aggregated and anonymized, value recorded without a street name or lot number, signed by a trustee whose authority does not require explanation, because the records that would have demanded one no longer circulate. The next step of the investigation follows naturally. Once a beneficiary is identified, something else must give way. Names fade, references thin, and eventually entire lines disappear from the record. That disappearance, and how it was made to look ordinary, is where the trail leads next. By 1916, the change that had begun as a technical adjustment and matured into fiduciary advantage completed its final institutional phase: disappearance. Not demolition, not abandonment, but the removal of reference points that allow history to be followed with certainty. This phase is quieter than any decision or alteration that preceded it, because it takes place inside the city archives, where survival depends less on prominence than on indexing. What vanishes here does not need to be destroyed to become unreachable. It needs only to stop being findable. The archival environment of the early 20th century was selective by design. Photographs, inspection images, and exterior documentation were not preserved indiscriminately. They were catalogued according to subject headings, property names, parcel identifiers, and departmental relevance. A building that retained its name and number could be retrieved through multiple paths. A building that lost those anchors relied on chance. In 1916, that chance appears to have run out. The action that defines this block is concrete and procedural. Official photographs tied to the property were either discarded or never indexed in a way that preserved their connection to the site. The city archives did not mark this as a purge. There is no notation announcing removal. Instead, what survives is absence, searches that return adjacent structures, related streets, and comparable residences, but not this one. Exterior images that should exist, given the period's routine documentation of prominent buildings, do not appear under any stable reference. The photographs themselves may have been physically discarded, or they may still exist without identifiers that link them back to the property. From a historian's perspective, the effect is the same. This absence extends beyond imagery. By 1916, the name of the house no longer appears in the archival pathways that once connected architecture to memory. Named residences were common reference points in newspapers, society pages, and municipal records. Their names served as shorthand for location and status. When the name disappears from the archive's index, the building loses its narrative handle. It cannot be easily cross-referenced against events, ownership changes, or civic activities. The building becomes anonymous in retrospect, even if it remained visible in its own time. Fiscal mentions follow the same pattern. Assessment references that once linked the property to routine taxation cycles thin out and then stop. This does not require a dramatic exemption. It requires only that the property no longer appears as a standard indexed parcel. Without a stable identifier, later fiscal records cannot easily point back to earlier ones. The trail breaks, not because records are falsified, but because the chain that connects them is interrupted. What makes 1916 the year of consolidation is not a single document, but convergence. By this point, the earlier map alteration has propagated through administrative use. The trustees' consolidation has removed the incentive for public accounting. The archival system now reflects the new reality by omission. The city archives become the place where disappearance hardens into fact, not because something is actively hidden, but because nothing points to it anymore. This is where disappearance differs from secrecy. Secrecy suggests an object actively concealed. Disappearance suggests an object no longer reachable through ordinary means. In the archival context, reachability is everything. Historians, attorneys, and journalists do not search the entire archive. They follow indexes. They trace references. They rely on names, numbers, and categories to narrow the field. Remove those, and the search becomes speculative. Speculation rarely survives peer review or legal scrutiny. What cannot be cited cleanly cannot be argued forcefully. The consequence of this disappearance is immediate and lasting. Direct historical tracing becomes impossible. One can infer, align, and compare, but one cannot point to a single continuous documentary line that carries the property from its documented presence into the later record. Gaps appear where confirmation should exist. Questions that could once be answered by pulling a file now require reconstruction from peripheral sources. This shifts the burden of proof. The absence itself becomes the obstacle. This outcome is not accidental in its effect, even if it is procedural in its execution. Archival systems reward stability. They preserve what is consistently referenced and allow the rest to fade. By 1916, the property has lost the attributes that generate consistent reference. It no longer has a map number. It no longer has a publicly used name. It no longer appears as a standard fiscal unit. The archive responds accordingly, not with malice, but with indifference. There is a narrow reflection permitted here. Institutional silence is not always imposed. Sometimes it is allowed, and once allowed, it compounds. Each year that passes without new references makes recovery harder. Each new filing built on the altered baseline pushes the earlier state further into the past. Eventually, the absence begins to look natural. Future archivists inherit a record that already assumes the property was never meant to be found. This does not mean nothing survives. Peripheral traces remain, indirect mentions, neighboring documentation, planning materials that imply rather than state. But these are fragments, not pathways. They require interpretation, and interpretation is always weaker than citation. The city archives by 1916 no longer offer a direct route to the property's visual or nominal identity. The building has crossed a threshold from documented object to inferred presence. The tension resolved by this block is the completion of the erasure process. We have moved from altered classification to altered maps, from altered maps to fiduciary benefit, and now from benefit to disappearance. What has left the record is not the building itself, but the means to prove its continuity without reconstruction. The disappearance is administrative, not physical, and that distinction is what makes it durable. The closing image is unambiguous and restrained. An archival finding aid dated after 1916, its headings intact, its cross-references orderly, and under the corridor where the residence once stood, no entry, no photograph, no name, only a clean sequence that skips over the space entirely. The investigation is now forced forward by necessity. When something disappears so completely, the next step is to examine what doesn't align, dates that don't reconcile, values that don't match, signatures that appear where they shouldn't. Absence invites inconsistency, and that inconsistency is where the record begins to resist the silence imposed upon it. After disappearance hardens, the record does something that systems often do when they've been bent too far. It produces an inconsistency, not a confession, not a reversal, but a line item that doesn't belong. In 1921, a document from the Tax Records Office surfaces that mentions built square footage, improved area, without a corresponding address that can be matched to the corridor's known parcels. It reads like routine administration, yet it contains a factual claim that should be impossible in a properly indexed environment. That is what makes it valuable. It is not dramatic. It is wrong in a specific way. The document is not a photograph and not a map. It is the kind of internal taxation record used to reconcile assessments, confirm improvements, and justify charges that would otherwise be disputed. In a normal case, such a record is tethered to a parcel, identifier, an address, or both. The tether is the point. It allows the city to defend itself if challenged. Here the tether is missing. The record refers to an improved area, assigns a generic charge, and yet provides no stable property identification that would allow a direct match to any address on the revised maps in circulation after 1913. The action is concrete and plain. The Tax Records Office issues a generic assessment charge that functions as a fiscal acknowledgement without naming the asset. It is a bill that knows something exists but refuses to say where. That is not how the system is designed to behave. If the city is willing to charge, it is usually willing to name. Naming is how payment is compelled and how disputes are contained. A generic charge without a corresponding address invites challenge. Unless the parties involved have reasons not to challenge it, or unless the structure of the charge is meant to avoid exactly the kind of visibility that a dispute would generate. The inconsistency deepens when you look at the numbers the record implies. The valuation associated with the improved area is not merely slightly off compared to neighboring parcels, it is incompatible. It sits outside the expected range for that block, given the known assessed values and the typical ratios applied to adjacent residences and lots in that period. In other words, it does not behave like a clerical misky. Clerical errors usually preserve the shape of normalcy. They make the right kind of mistake. This record makes the wrong kind. It produces a value that suggests an improvement level not accounted for in the surrounding tax environment, either too high to be a minor structure or too concentrated to be a typical subdivision. This creates a narrow but powerful conclusion, one that still does not require speculation about motive. If in 1921 the Tax Records Office acknowledged built area without an address, and if the associated values do not reconcile with neighboring parcels, then something remained within the system without being fully inside it. The city's fiscal machinery knew there was an improvement to account for, but the city's public-facing identification machinery, maps, parcel numbers, named residences, did not provide a clean way to point to it. The record sits at the seam between two realities: the administrative reality, designed for visibility, and the administrative workaround, designed for silence. It is important to keep the narrative discipline here. This inconsistency is not proof of a single hidden mansion still generating secret revenue. It is evidence of a structural mismatch. The city charged for built square footage, but did not attach that charge to an address that can be found in the revised cartographic record. That mismatch, by itself, is evidence that the earlier alteration and disappearance had not fully eliminated the asset's fiscal footprint, it had only distorted it. Why would a generic charge exist at all if the goal was total invisibility? Because total invisibility is difficult. Systems that eliminate identifiers often still need to keep internal accounts balanced. Governments operate on ledgers. Even when something is administratively inconvenient, it must still be reconciled somewhere. The charge suggests that the city maintained some internal awareness of the improvement, perhaps under a technical category, perhaps under a consolidated notation, perhaps under a trust-related handling that did not translate into address-based indexing. The record is a compromise. Enough acknowledgement to keep the books coherent, not enough specificity to make the asset easily traceable. The numbers are what keep the inconsistency from being dismissed. A generic charge could be explained away as an accounting bucket, a temporary placeholder, or an error of filing. But when the valuation is incompatible with the corridor's known assessment profile, the explanation narrows. Either the value corresponds to a significant improvement being handled off-record in the ordinary mapping system, or the corridor's official assessments were being shaped to accommodate a parcel that did not appear as a parcel. In both scenarios, the consequence is institutional. The tax system is not simply missing an address, it is absorbing a reality it cannot publicly name. This is where the investigation advances rather than merely darkens. The inconsistency becomes a diagnostic tool. It tells us the disappearance was not perfect. It tells us there were points where the system still had to acknowledge the property's physical existence in order to function. That creates a new pathway for proof. Instead of searching for photographs that no longer index or names that no longer appear, we can follow the fiscal logic. Where did the generic charges accumulate? How often did they occur? Did they recur annually or appear only once? Were they associated with a technical designation? Did they correspond to a ledger? Category known to be used for easements, infrastructure corridors, or trustee-held assets. The consequence is real and concrete. The 1921 record becomes evidence that something was maintained outside the normal identification system while still interacting with municipal finance. It points to an asset that was not fully erased but partially insulated, an improvement that remained on the city's internal balance sheet without being fully present on its public map. That is the kind of evidence institutions fear because it does not require a whistleblower. It requires only arithmetic and comparison. If you're watching this and wondering whether this is a one-off error or a recurring pattern, hold that thought, subscribe so you don't miss the next file, and if you've seen generic charges used to avoid specificity in any system, leave a like. The tension resolved here is the emergence of a point that does not close. The system's attempt at silence produced a line that refuses to reconcile with its surroundings. The disappearance may have succeeded in archives and maps, but by 1921, the fiscal machinery still created a trace, built area charged without an address, values incompatible with neighboring parcels, a sign that something remained partially outside the system while still being accounted for within it. The closing image is procedural and precise. A thin tax ledger sheet from 1921, a column labeled for improvements, a generic charge entered without a street reference, the amount standing out against the block's normal range, and beside it an empty field where an address should be, blank space that reads less like a mission now and more like a method. The next topic follows the only logical escalation. If records like this were ever connected publicly, the risk wouldn't be theoretical. It would be immediate. Litigation, headlines, and institutional exposure that would force the city to explain why it charged for something it refused to name. Once an inconsistency exists, the danger is no longer archival, it becomes public, and between 1918 and 1920, that danger carried a particular weight that explains why silence did not merely persist, but hardened. The period was politically volatile. The war had just ended, cities were renegotiating their social contracts, newspapers were expanding their reach, and investigative reporting was no longer confined to crime or labor. It had begun to touch wealth, privilege, and the mechanics that protected both. In that environment, a single confirmed example of a property that existed outside the normal civic system would not have remained a technical curiosity. It would have become a test case. The risk was not hypothetical. By this point, the elements were already present for a scandal to form. There were revised maps that no longer aligned with earlier ones. There were fiscal records that acknowledged built area without an address. There were trust structures that benefited from opacity. All that was missing was narrative coherence, and that is precisely what the press could supply. A story that connected those elements would not have needed speculation. It would have needed only juxtaposition. This is where the role of the Metropolitan Press Association becomes relevant. In the late 1910s, the association functioned as a coordinating body among major urban newspapers, shaping what was pursued aggressively and what was treated as marginal. It did not issue public bans. It did not need to. Its influence operated through editorial norms, shared priorities, and an unspoken understanding of which subjects promised institutional conflict rather than circulation gains. Property stories were not neutral. They implicated advertisers, benefactors, and political allies. They also implicated city agencies that papers relied on for access. The action that defines this block is subtle, but documented in pattern: the suppression of sensitive property-related agendas. Stories that touched on irregular land treatment, unusual assessments, or unexplained omissions were deprioritized, softened, or redirected. They did not vanish entirely. They were reframed as administrative confusion or deferred until confirmation could be obtained from offices that had no incentive to clarify. In effect, the burden of proof was raised to a level that ensured delay. Delay, in journalism, is often indistinguishable from disappearance. The reason this mattered between 1918 and 1920 is that public appetite for accountability was high. Progressive reform movements had normalized the idea that privilege could be interrogated. If a case emerged showing that an elite property had been deliberately removed from public maps, shielded from taxation norms, and still quietly accounted for in internal ledgers, it would have fed directly into broader critiques of land privilege and unequal governance. It would have invited questions not just about one residence, but about how many others existed in similar limbo. The risk extended beyond embarrassment. A confirmed exposure would have triggered cascading consequences. Legally, it could have reopened inheritance disputes thought to be settled. Heirs and creditors could argue that assets had been improperly shielded, demanding re-examination. Institutionally, it could have forced city departments to explain discrepancies between public records and internal accounts. That kind of explanation rarely ends cleanly. It spreads. It invites audits. It produces memos that do not stay internal. Financial markets, too, were sensitive to perception. Elite stability depended on the assumption that property rights were secure and legible. A public demonstration that legibility could be selectively withdrawn would have unsettled that assumption. Investors might begin to question the reliability of municipal records. Reformers might push for standardization that eliminated discretion. What had been a quiet advantage could quickly become a liability. In this context, continued silence was not inertia. It was risk management. The Metropolitan Press Association did not need to conspire with city officials or trustees. It needed only to recognize that certain lines of inquiry would destabilize more than they revealed. Editors understood that a story exposing privileged land treatment would not end with a single article. It would demand follow-up. It would demand sources. It would demand documents that, once requested publicly, could not be quietly declined. The consequence of this dynamic is institutional reinforcement. Silence in one system encourages silence in another. When the press does not ask, departments are not forced to answer. When departments are not forced to answer, trust structures remain undisturbed. When trust structures remain undisturbed, beneficiaries retain their insulation. Each layer benefits from the restraint of the others. This is not conspiracy in the cinematic sense. It is alignment of incentives. What makes the risk phase distinct from earlier ones is that exposure now threatens to reverse the entire sequence. Discovery could become headline, inconsistency could become accusation, alteration could be framed as manipulation, beneficiaries could be named, the story would not be about a missing lot. It would be about how cities protect certain forms of wealth while presenting an image of neutrality. That is a narrative institutions fear because it reframes technical decisions as moral ones. There is a limited reflection allowed here. Reputation is not preserved only by what is said. It is preserved by what is never assembled into a story. The cost of reputation in this period was not paid up front. It was avoided through restraint, by ensuring that fragments never became a whole. This block resolves the tension around why the inconsistency did not explode into scandal when it appeared. The reason is not absence of evidence, it is presence of risk. Between 1918 and 1920, the political, social, and media environment made exposure uniquely dangerous. The potential fallout touched too many interests at once. Silence was not simply tolerated, it was preferred. The closing image is restrained and procedural. An editorial meeting table in the late 1910s, a proposed property brief set aside in favor of safer copy, its questions unanswered not because they lacked merit, but because answering them would have required institutions to speak in ways they were unprepared to do. With that risk contained, the system could settle into something more durable than silence. It could normalize the absence, transforming an extraordinary omission into an unremarkable fact of the record. And that normalization is the next stage the investigation must confront. By the mid-1920s, the most durable kind of concealment was no longer concealment at all. It was routine. After the political volatility of 1918 to 1920, after the uneasy fiscal trace in 1921, the institutions around this corridor did what institutions do when a problem threatens to become a story. They reduced it to vocabulary, not a public statement, not a dramatic policy, a set of terms that made the anomaly legible inside the bureaucracy while keeping it uninteresting to anyone outside it. The year that marks this shift is 1925, not because something new was erased, but because the language of the record changed in a way that made erasure feel ordinary. If the earlier steps were about removing identifiers, numbers, names, photographs, this step is about replacing them with phrases that cannot be argued with, phrases that do not invite follow-up because they sound like maintenance rather than meaning. Once those phrases appear consistently in files, the absence stops reading like an event. It starts reading like a category. The entity that gives this category permanence is the Historic Preservation Office. In the public imagination, preservation is romantic, restoring facades, protecting landmarks, telling stories of what came before. In the administrative world, it is also a filing system. It decides what gets described, what gets listed, and under what headings. It creates inventories that other departments reference when they need to justify why a space is handled differently. In 1925, the office's involvement does not arrive as a celebration of a mansion or a formal landmark designation. It arrives as a classification move that sounds technical enough to be unquestioned. The action is concrete. The space is formally classified as a maintenance zone. That phrase appears in internal descriptions where a direct reference once might have existed. It replaces the property's former identity with a functional label. Maintenance zone implies that the space is not really a property in the ordinary civic sense. It implies an area reserved for access, service, inspection, protection of municipal assets, or buffer around infrastructure. It implies an administrative necessity. It does not imply a home, an estate, or an inheritance. Once the phrase is adopted, the rest of the system begins to comply without being instructed to hide anything. Clerks, copying information into new ledgers, replicate the term because it is the term they are given. drafting rooms shade the space or mark it as service-related because a maintenance zone is commonly treated that way. Archivists index under function rather than name because function is all that remains. Over time, the zone becomes easier to store than a property ever was because it no longer needs a narrative, only a label. This is how silence becomes stable. A named place creates obligations. It creates questions. It can be subpoenaed into court, written into a newspaper, attached to an heir's petition, or flagged by an assessor. A maintenance zone creates almost none of that. It suggests there is nothing to inherit, nothing to litigate, nothing to expose. It sounds like the kind of administrative matter that cannot sustain a scandal because it does not offer a hook. People rarely demand the lineage of a maintenance zone. They rarely ask why a maintenance zone carries unusual valuation logic. They rarely request exterior photographs of a maintenance zone. Even the act of asking begins to sound naive, as if the request misunderstands how cities work. What changes most in this phase is not what exists on the ground, but how the bureaucracy describes what exists on the ground. Vague language replaces direct records. References that once would have been anchored to a parcel number become anchored to function. Memos that might once have said, "Residence shift to area." Requests that might once have required a street address are routed through generic descriptions. When an office needs to justify restricted access, maintenance zone does the work without explanation. When a file needs to be cross-referenced, it is cross-referenced under maintenance schedules rather than property schedules. When a map needs to be updated, the space is treated as technical rather than civic. This also resolves a practical problem created by the earlier inconsistency. A generic tax charge in 1921 without an address is the kind of thing that could provoke internal discomfort. It implies that the books know something the maps won't admit. Normalization offers the bureaucratic fix. Once the space is framed as a maintenance zone, internal accounting can continue without requiring a public-facing identifier. The charge can be justified as related to maintenance allocation, service access, or technical oversight. It stops looking like an unexplained pocket of wealth and starts looking like the cost of running a city. The label provides cover, not by denying the space exists, but by changing what the space is allowed to mean. The Historic Preservation Office's role gives the label additional durability, because preservation files tend to be treated as long-term truth. When an inventory says a space is a maintenance zone, later staff accept it as inherited classification rather than contested description. This is not malice. It is how office memory works. People assume the people before them did the thinking. They assume the label is the result of process. They treat it as settled. The longer the label persists, the harder it becomes to challenge without seeming unreasonable. Challenging a missing house sounds investigative. Challenging a maintenance zone sounds like paperwork obsession. That is the core consequence of normalization. The erasure begins to appear administrative, not intentional. The public record no longer contains a visible rupture because the language used to describe the space has been designed to contain rupture. The gap between early maps and later maps is now bridged by a category that explains absence as function. The archive's missing photographs can be explained as lack of public frontage. The lack of a name can be explained as non-residential status. The missing fiscal mentions can be explained as non-standard handling. Each absence gains a plausible administrative interpretation, and plausibility is often enough to end inquiry. The most effective part of this normalization is that it requires no continuing conspiracy. Once the vocabulary is in place, the system perpetuates itself. New clerks are trained on existing terms. New inspectors follow established routes. New maps are drafted from prior drafts. New Preservation inventories copy forward old classifications. The silence becomes an inherited habit. It becomes the background texture of how the city describes that stretch of corridor. That is why normalization is more powerful than alteration. Alteration is an act. Normalization is a climate. There is a restrained reflection that fits within the record without turning it into philosophy. In most institutions, the difference between something unusual happened and nothing unusual happened is often just the language used to file it. When a file is titled correctly, it stops looking like a problem. When a space is categorized correctly, it stops demanding explanation. That is the quiet sophistication of administrative power. It does not always need to remove things. It can rename them into silence. The tension resolved by this block is clear. After risk and inconsistency, the system needed a stable way to avoid further attention. In 1925, the adoption of generic technical terminology, anchored by the Historic Preservation Office and operationalized through the classification of the space as a maintenance zone, provides that stability. From this point forward, the omission no longer reads like a suspicious absence. It reads like routine governance. The closing image is concrete and bureaucratic, the kind that survives when stories do not. A single inventory card from 1925 in a preservation file drawer, typed in plain language, bearing the phrase maintenance. Zone, stamped and initialed, with no house name, no exterior photograph reference, and no parcel number, only a category that sounds final. The next stage of this investigation is unavoidable, because categories like this are meant to endure. The question is what happens when decades pass, cities modernize, records go digital, and the present finally tries to locate a place that the paperwork taught itself not to name. In 2024, the investigation reaches a point where the past stops being historical and becomes operational. The question is no longer whether a property was altered on paper a century ago, but whether the modern systems that claim to show everything can find it now. The test is simple, contemporary, and repeatable. The address is entered into Google Maps. The result is not a correction notice, not an outdated PIN, not an archived reference. The result is nothing. No match, no suggestion, no historical layer that resolves the gap. The digital map behaves exactly as the revised paper maps did after the early 20th century. It closes over the absence. This is not a failure of technology. Modern mapping platforms ingest municipal GIS data, postal records, historical baselines, satellite imagery, and user-generated confirmations. When something fails to appear across those layers, it is usually because the underlying identifiers never made the transition into the datasets that power search and display. Digital systems do not invent addresses. They inherit them. They amplify what has already been formalized and indexed. In this case, what was normalized as silence in the 1920s becomes authoritative absence in the 2020s. The action that defines the present is therefore concrete and measurable. The address does not exist in modern digital bases. It cannot be located, verified, or resolved through the tools most people trust to confirm reality. This is not because the physical space vanished. Satellite imagery still shows a corridor, still shows continuity of land use, still shows boundaries that reflect a long history of occupation and maintenance. What is missing is the semantic layer, the naming, numbering, and identity that allow a place to be called by name in a system designed for retrieval. What remains intact is the official narrative, not as a story told aloud, but as an assumption embedded in data. The area appears as it has appeared for decades, functionally defined, technically categorized, administratively unremarkable. There is no prompt in the system that suggests something used to be there under a different status. There is no flag indicating historical reassignment. The silence that was normalized through paper files, internal classifications, and generic terminology has been faithfully carried forward into the digital age. This continuity matters because digital mapping is often treated as corrective, as if technology naturally uncovers what older systems concealed. But technology is conservative in a specific way. It trusts inputs. It trusts the inheritance of records. If a property's identity was stripped before standardization, it enters the digital era already diminished. Algorithms do not question why an address never existed. They simply accept that it did not. The consequence is not merely academic. When a place cannot be located digitally, it cannot be easily discussed, visited, contested, or reinterpreted. Researchers cannot cite it cleanly. Journalists cannot link to it. Legal. Inquiries cannot anchor claims to a searchable reference. Even well-intentioned attempts to reconstruct the past are constrained by what modern systems will acknowledge. The present inherits the limits imposed by earlier administrative decisions, and those limits harden as time passes. This is where the investigation's arc becomes visible in a single gesture. A decision made in 1911 shaped a map in 1912. A disappearance consolidated in 1916 thinned the archive. A normalization in 1925 reframed the space as technical rather than civic. A digital search in 2024 confirms the cumulative effect. Each step was modest. Each step was defensible in isolation. Together, they define what the present is allowed to find. There is no need here to accuse modern platforms of complicity. Their role is mechanical. They reflect, they aggregate, they display. The responsibility lies upstream, in the record logic that determined what would count as a place and what would count as function. Once that distinction was settled, everything that followed, including satellite-era mapping, fell into alignment. The present also reveals something else. The absence no longer looks suspicious to casual users. It looks normal. When an address cannot be found, people assume user error, renaming, redevelopment, or simple non-existence. The system trains its users to accept silence as fact. That is the final success of normalization. It converts historical erasure into contemporary common sense. There is a restrained reflection permitted at this stage, and it belongs to the mechanics of memory. Digital tools do not remember independently. They remember what institutions have already agreed to remember. When a place is removed before the age of databases, it does not wait to be rediscovered. It waits to be confirmed as absent. This block resolves the last operational tension. The past has not merely influenced the present, it has bounded it. What can be searched today is shaped by what was allowed to exist administratively a century ago. The disappearance has outlived the people who authorized it, the offices that implemented it, and the paper that first recorded it. It persists as a negative space inside systems designed to be exhaustive. The closing image is contemporary and precise, a blank search result in 2024, a modern interface returning no location where a residence once stood, the map smoothly rendering streets and parcels around an empty query. No warning, no explanation, just a system behaving exactly as it was trained to behave. The investigation does not end with revelation, but with constraint. The understanding that what the present cannot locate is often the most reliable evidence of what the past chose not to leave behind. What the present adds, beyond confirmation, is friction, not resistance from institutions, but resistance from the tools designed to resolve uncertainty. In 2024, when investigators attempt to reconcile physical observation with digital, Certainty, they encounter a boundary that is neither technical nor accidental. Modern systems are built to reconcile conflicts, duplicate addresses, renamed streets, merged parcels, yet, in this case, there is nothing to reconcile. The systems do not register a conflict because, from their perspective, no contradiction exists. The absence has been internalized as coherence. This becomes clear when contemporary verification methods are layered. Cross-checking municipal GIS feeds, postal normalization services and commercial mapping APIs yields alignment rather than discrepancy. Each system agrees with the others not because they share a conspiracy, but because they share a lineage. They inherit the same base assumptions about what constitutes a valid address. Once an assumption has been stabilized for long enough, it ceases to be tested. Verification processes are designed to resolve differences, not to question inherited nulls. The present also introduces a procedural limit that did not exist a century ago. The expectation that everything searchable is everything that matters. Researchers increasingly rely on digital confirmation as a prerequisite for inquiry. If a place does not resolve digitally, it often fails to qualify for deeper investigation. Grant proposals, institutional reviews, and even journalistic pitches can stall at the first step, not because evidence is lacking, but because the evidence cannot be anchored to a recognized reference point. The system filters curiosity before it becomes inquiry. This has a secondary effect on accountability. Contemporary oversight mechanisms, audits, public records requests, historical reviews are scoped by what can be named precisely. When a space lacks a recognized digital identity, it becomes difficult to target. Requests must be specific to be actionable. Oversight bodies require identifiers to open files. Without them, inquiries are redirected, narrowed, or deemed unfounded. The absence functions as a shield, not through secrecy, but through procedural insufficiency. What is particularly striking in the present is how often this condition is misread as finality. The inability to locate a place digitally is taken as proof that it never mattered, rather than as evidence that it once mattered enough to be managed carefully. This inversion is subtle but powerful. It turns erasure into insignificance. Over time, that logic rewrites historical importance retroactively, allowing present-day narratives to exclude what the record no longer names. The present also reveals the durability of administrative language. Terms introduced to normalize silence decades ago continue to structure access today. Digital layers reflect zoning categories, functional designations, and service areas that descend directly from earlier classifications. When a space was framed as technical rather than civic, that framing propagated forward, shaping how data engineers, planners, and archivists understood it long after the original context was forgotten. The vocabulary outlived the intent. There is also a human consequence that becomes visible only now. Residents, researchers, and local historians who sense that something is missing encounter a paradox. Oral memory hints at continuity, physical inspection suggests persistence, yet every formal attempt to locate the place collapses into ambiguity. This gap erodes confidence not in the past, but in the tools meant to explain it. People learn to distrust their own observations when systems return silence. The present teaches compliance by design. What remains unexplained is not the disappearance itself, but the threshold beyond which recovery becomes impractical. At what point does absence become irreversible? The present suggests an answer when the cost of reintroducing a name exceeds the perceived benefit. Reinstating a historical identity would require reopening classifications, reconciling datasets, and acknowledging that the system once chose not to see Institutions are reluctant to do this without compelling pressure, and compelling pressure requires evidence that the system currently refuses to surface. This creates a self-reinforcing loop. The more complete the digital silence becomes, the harder it is to justify the work needed to break it. Each year that passes adds another layer of inherited certainty. The present does not actively defend the absence, it simply lives with it, and living with it becomes the path of least resistance. The extension of this topic ends with a practical constraint rather than a revelation. In 2024, the place cannot be located not because it is hidden, but because the systems that define location were never taught to recognize it. The past set the parameters, the present enforces them automatically, and until those parameters are challenged deliberately, the absence will continue to present itself as fact. Not as a mystery to be solved, but as a non-event that no longer qualifies for explanation. In the end, the most unsettling detail is not that a house could be lost, but that it could be unmade without ever falling. A place entered the city's paper memory in 1898 with the ordinary certainty of ink and approval, then passed, step by step, into a century of administrative quiet. The streets remained, the corridor endured, yet what defined the residence as a locatable truth was thinned, revised, and finally replaced by language designed to sound like routine. And by 2024, the modern map does what the old ledgers taught it to do. It renders the city smoothly, and it leaves no place for the name that once belonged there. This is how power behaves when it is most confident. It does not always forbid, it reclassifies. It does not always destroy, it declines to index. It does not always erase with violence. It erases with procedure, with categories, with maintenance and technical, and other words that carry the weight of inevitability. We tend to imagine archives as neutral vaults, silent rooms where history waits, intact, for whoever is patient enough to ask. But archives are not only storage, they are borders. They decide what can be retrieved, what can be proven, and what can only be suspected. That is why the Library of Congress matters in this story, even if it never appears as a villain and never needs to. The great institutions of preservation show us a difficult truth. What survives is not merely what existed, but what was allowed to remain legible. Preservation is selective by nature. It is constrained by what is submitted, what is catalogued, what is described with stable identifiers, what is judged worthy of retention, and what is quietly left to drift into obscurity. When a place loses its name and number, it does not simply vanish from a map. It slips beyond the reach of the very systems built to safeguard memory. And once it slips there, it can influence the present without being fully seen in it. The consequence is not confined to one vanished residence. It is institutional. It shapes what can be searched, what can be cited, what can be contested, and what can be inherited as unquestioned fact. The past does not only inform the present, it defines the edges of what the present can locate. In a world that trusts databases and digital certainty, absence becomes a verdict. Not because absence is proof of nothing, but because modern systems treat inherited gaps as settled reality. The silence is no longer a mystery. It is a function. So the case remains open, not because we lack fragments, but because the clean chain was broken by design. A map revised without publication, a name removed without replacement, photographs discarded or never indexed. A fiscal trace that acknowledges built area, yet refuses to say where it stands. And in the distance, the steady machinery of institutions that continue, decade after decade, to behave as if the omission was always normal. If you have your own interpretation of what this corridor has been trained to forget, leave your thoughts below. Every perspective helps illuminate what history tried to bury. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. And consider subscribing so that you're here when the next sealed door finally opens, because the pattern rarely ends with one vanished room. And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive not because they are unspeakable, but because those who feared them left no one to tell the truth.